Our Attorney General is someone who knows how to keep himself in the news. He's regularly in the news. He keeps himself there. And there was a bill that recently passed. The bill was, I believe the bill had something to do with revenge sharing of exposed pictures or videos or content in general. There was a recent bill passed to make sure that people, especially women, because they are the ones who fall victim to this most, have a legal way to get something done when they have this done to them. That bill passed. And the Attorney General went on to lament about a previous bill that had some of these same things in it that he wanted to pass also. And that bill did not pass, and he was lamenting about it and about the state of the crime detection rate in Trinidad and Tobago. Let's get into it. Let's get into exactly what he spoke about there. Attorney General, sex crime detection, shame, laments non-passage of Cybercrime Bill 2017. Of 2,282 sexual offenses reported in Trinidad and Tobago in the past 5 years, 647 were detected at a detection rate of 28.3%. The Attorney General said. He delivered these statistics as he lamented the Parliament's failure to pass the Cybercrime Bill 2017. That would have addressed some digital-based offenses such as voyeurism, revenge porn, and capturing and sharing of images of a personal nature without consent. The Attorney General was piloting in the Senate the second reading of the Sexual Offences Amendment Number 3 Bill 2021, which he called complicated, and said government was putting out a suggestion on policy. With the failure to pass of the cybercrime legislation, Al-Rawi said some means for mitigating crimes of such a nature was now being attempted through this new bill. The figures given by the Attorney General was a previous report. All right. So the Attorney General is basically saying that because the opposition, he went on to blame some on the opposition, because the opposition, he said this numerous times as he spoke about this, because the opposition didn't allow the passage of this Cybercrime 2017 bill. Do you feel like all this forced vaccination thing is all about scoring political points? No, I don't think forcing vaccinations is about scoring political points, because I don't think there are political points to be scored by forcing people to become vaccinated. So no, I don't think so. Right, he lamented over and over and over. Why did they not pass this bill in 2017? And I started trying to remember this bill, and to me I remember that this bill had some complicated history with it. So I went to look back on it again, because I like information and I'm curious like that. And I found that bill again, and I find it, personally, I found it dishonest when he was doing it back then, and I find it now to be dishonest to try to pass this Cybercrime Bill 2017 and use as an excuse the gendered violence and the gendered victimization of online sharing of revenge porn, etc. And say that this bill was the only way this could have been done, and because we didn't get this bill passed, that's why these other things didn't happen. But look, you got it done in a new bill, so you didn't actually need the cybercrime bill to get these things passed. And there were several other things attached onto the cybercrime bill that had nothing to do with gendered violence and releasing people's nudes. Let's take a refresher. Going back to an article from May 22nd, 2017 from Loop. 10 things to know about the Cybercrime Bill. Government announced its intention to reintroduce the Cybercrime Bill 2015. This is old news. This is back in 2017 in Parliament that year, causing concern. There are several things, especially the media fraternity had several problems with this bill. Here are 10 things about the Cybercrime Bill that might affect the sharing of information online. And now, 2017 was a lot different than now. This cybercrime bill would have an even greater effect when you look at these laws. If this cybercrime bill had passed back then, the effects it would have had now, especially I was seeing late last night, right around the close of the live, about some of the bacchanal going on TikTok. This bill would have had some impact even on that. Even on me talking here, this bill would have had an impact on. All right. Here are 10 things you need to know. 10 things you needed to know about that cybercrime bill according to Loop. There's $1 million fine and 3 years imprisonment for copying data. Section 8 of that bill says any person who intentionally and without lawful excuse or justification copies computer data to any computer data storage device or to a different location within the computer system, or moves computer data to a computer storage device or a different location within the computer system, if found guilty, could be sentenced to 5 years imprisonment or a $2 million fine. Now, here's the thing with this. Here's how that works against journalists. A lot of journalism has to do with you finding information from people that they didn't want found. No, that would be considered copying it. If you copy any data that you didn't have permission to copy, you can go to jail. Bear in mind, the bill didn't pass. I'm glad it didn't pass. But our Attorney General, our present Attorney General, is saying that he's angry that this bill didn't pass. And because this bill didn't pass is why so many young ladies are suffering at the hands of nefarious men who are trying to abuse them online. That's what our Attorney General is saying. That because now we cannot charge people for copying information, that's why these young ladies are suffering. All right, here are some further things on that. The Media Association went in on their problems with that. Number 2, accessing computer data without a lawful excuse. Under Section 9, any person who intentionally and without lawful excuse or justification acquires computer data without the consent of the owner, whether for personal use or use by another person, may be subjected to a fine of $100,000 or 2 years imprisonment on conviction. So, if you acquire computer data without the consent of the owner, all you need to do is not have permission and you could be in jail. Number 3, jail time for sharing information even if you didn't know. Section 13(1) of the bill says accessing information without lawful excuse or justification is a criminal offense, even if you didn't know it was shared unlawfully. A person who is not authorized to receive or have access to computer data commits an offense if he intentionally and without lawful excuse or justification receives or gains access to the computer data from another person, whether or not he knows that the other person obtained the computer data through authorized or unauthorized means. So, I get my information, I copy it, I go on someone's WhatsApp, take a screenshot or something, or take a picture of their phone, and I send you that picture. And all of a sudden, you could make a jail because you got information. You didn't even know how I got the information. All you do is you got the information yourself. Now, this might have even created, so now your data have to come with a chain of custody. Now, this might have created some problems even with social media, because let's say I shared something online that I got through an unauthorized means, and then you took what I shared, for example, on TikTok. So let's say I did a contemplation, and in my contemplation I included a picture that I got from somewhere else, and you took my nice TikTok and you shared it. All of a sudden, you are partner to a crime. You are partner to a crime. Now, bear in mind, in 2017, social media still wasn't like how it is now. So, some of this couldn't have even been foreseen in that way. But I am glad this bill didn't get through. The journalists back then were some of the main ones really upset about this. But the position many of us find ourselves in now, in the current setup of the internet and social media, all of us would have been breaking a lot of these rules. A lot of us would have been breaking a lot of these rules. Number 4, no protection for whistleblowers. Whistleblowers may be criminalized for emailing journalists under the cybercrime bill. Section 13 states a person who intentionally and without lawful excuse or justification initiates the transmission of multiple electronic mail messages from or through a computer system or uses a computer system to relay or transmit multiple electronic mail messages with the intent to deceive or mislead a user or internet service provider as to the origin of the message could be subject to prosecution. Whistleblowers would be the kind you find out something wrong. You find out something wrong is going on in this company or in this institution, and you're there inside, and you're on the inside, and you say, wow, I can't let this happen. My conscience, I cannot sleep at night knowing this is happening inside of this company, inside of this institution, inside of this organization. I need to let someone know something. So what I'm going to do, I'm going to reach out to Mark Bassant and try and get my story shared out there. I want an investigative journalist, and I'm going to become a whistleblower. Now, even doing that could end you up like Snowden or like Julian Assange and end you up in jail for doing the right thing. And yes, I find it very suspicious that Mr. Al-Rawi is still so intent on wanting to pass this bill. Now, there were parts in the bill that did include things about people who like to interfere with little children. They included things about revenge porn. There was an interesting part here, and this is where TikTok might be interested. Number 7, cyberbullies will be punished. Section 20 of the bill seeks to criminalize the act of cyberbullying or causing fear, intimidation, humiliation, distress, or other harm to another person or detriment to another person's health, emotional well-being, self-esteem, or reputation. Anyone found guilty of cyberbullying by threatening to publish private information which can cause public ridicule, contempt, hatred, or embarrassment faces up to 5 years imprisonment or $1 million fine if found guilty. Listen, anything could be considered as causing fear, intimidation, humiliation, distress, or harm to any person. Listen, any contemplation, when I make a contemplation and I talk about the Attorney General getting, well, him and his family getting paid up to 20 million, according to the articles in the newspapers, getting paid up to 20 million in rent by our government while sitting in government. If I said this, he could sue me and tell me I caused distress on him and his family. That's nonsense. He could have called me a cyberbully just for talking about the news. Again, to be fair, this bill did not pass. You could, if you want to thank someone, you could thank the UNC for that. For those who may not be necessarily UNC fans, find it in your heart and thank the UNC members for this. Number 8, police can search your computer and or confiscate data. Under Section 23(1), authorities can issue a search warrant for the search and seizure of computer data once there are reasonable grounds the material was acquired in offense of the act. So if the police, and we know how our esteemed TTPS function in Trinidad and Tobago. Listen, if you're an officer and you're in the live, I'm not necessarily directing it at you, but we know, you would know if you're an officer and you're in the live, you would know how some of your own fellow officers operate in Trinidad and Tobago. So all the officers would have needed was reasonable grounds that the material you acquired illegally. Listen, nearly anything on my phone could be assumed to have been acquired from someone illegally. It's very easy. And then all they need is reasonable grounds for that. And they can take my phone and search through all of my data. Here's the second part. It says also that officers can also retain and copy data, remove data, and the computer from its location. Going on, number 9. Corporate bodies are also liable. Under Section 22, where a body corporate commits an offense under the Act, and the court, the director, manager, secretary, or other similar officer of the body corporate, or any person who purports to act in such capacity, either connived in or consented to the commission of the offense, the company could get it. So if your secretary, your director, or manager does their own nonsense, you as the entire company could have fallen out of that? Wow. Tough. That's tough. And number 10, according to the Loop article, is prevention from even speaking on matters during criminal proceedings. Under Section 28, once computer data is being used during criminal proceedings and confidentiality must be maintained, a person who is the subject of the order cannot, without lawful excuse or justification, disclose the fact that the order or notice has been made or the details of the order or notice. Now, watch how that works out against this, against journalism. If you're a journalist, if you're a journalist and you acquired some information and they have reasonable suspicion, they run in and start to acquire your data. You can't even write the story on the data you acquired. You can't even write a story on the fact that you are being investigated for the data you acquired. If you write even anything about it, you are now guilty of another offense. What were they trying to do? The amount of power that put in the hands of the government was insane. I think they had specific targets in mind. I wouldn't doubt it. I wouldn't doubt it. Now, I know I may be harping on about this, but I found this very interesting, and especially the fact that the Attorney General keeps bringing this up. He brought it up again in 2019, and in 2019 when he brought it up, he again blamed journalists for not supporting this bill, and because they didn't support this bill, they caused gender violence to continue. And I find it so, I'd use the word disgusting, to use something as sensitive and as explosive as something like gendered violence and use that to promote a bill that isn't ostensibly about gendered violence. The bill isn't, for the most part, about anything to do with that. The bill has to do with a whole lot more. Now, here's where I found even another article. As I said, I'd be harping on a little about this. Wired 868. Back in 2017, one Dr. Emir Crown, let me read his qualifications. He's a senior lecturer at Mona and a barrister. He is Dr. Emir Crown. Let me read those letters. BA, LLB, LLM, LLM, PhD, LEC. All the letters in the alphabet. He wrote an article condemning many of the parts of this law also. Let me see if I could get into some specifics so we don't have to go through the entire thing. First, the bill itself states that it is inconsistent with sections 4 and 5 of the Constitution. So, people who were thanking the UNC, this is why you could thank the UNC. Because the bill itself was unconstitutional in certain parts. It goes against some of the rights stipulated in our Constitution. So in order to do that, you need a 3/5 majority. They needed a special majority to pass the bill because it went against some parts of our Constitution. That's the first part. That's the first part scary in this bill. Second, the bill sets out several offenses, sections 5 to 19, but offers little in the way of defenses or exemptions. And the defenses or exemptions, the lawyer here, the doctor, the lecturer, is speaking about particularly journalists and the problem journalists would face in this. Now, I would extrapolate that to include many other members of the social media ecosystem now in this present time. And if that law was proclaimed back then, or if it's proclaimed now, it would affect way more than just the journalists. He went on to speak about the section 8 where it speaks about a person who intentionally and without lawful excuse or justification receives or gains access to a computer data knowing the same has been stolen. Some have suggested that this would in effect criminalize investigative journalism. That's partially true. All right, I'm looking for some more parts of this here. Third, and with the greatest of respect, several provisions simply, this is what the barrister is saying here. I have the same beard and mustache length. Ha. Well done, sir. This is what the barrister is saying here. Several provisions in the bill simply don't make sense. For instance, section 6 states, bear in mind the Loop article didn't go through the entirety of this bill. This article goes through some more insanity in the same bill. All this is in the same bill All this is in the same bill that the Attorney General is still trying to get passed and is still trying to tag on to something about gendered violence and sharing people's nudes online to get it passed. For instance, Section 6 states a person who intentionally and without lawful excuse or justification remains logged into a computer or part of a computer system or continues to use a computer system commits an offense. Undoubtedly, the provision is intended to cover situations where persons use a computer system after someone else has logged into it, like a computer terminal in a university or even an ATM. But the provision itself does not say that. Therefore, by logging into my laptop and typing this review, I have evidently committed a cyber crime. And that's the thing. This bill would have gone out there and criminalized so many actions. Yes, rant from Rantland. This bill would have gone out there and criminalized so many different actions, and many of the actions are very vague in how you express it. How could you have in our law books that it's a criminal offense for a person to intentionally and without lawful excuse remain logged into a computer system or part of a computer system? What do you mean? If I remain logged in, I'm committing an offense? You have to get better than that. And what it may be is some people without the computer expertise were trying to write the laws. That could be part of the reason. Now, the bill that speaks about releasing people's sensitive nudes online, I agree that should be a crime. There's no debate about that to me. And the fact is, that leans more towards a specific gender. But here's a question. If we're talking about releasing sensitive data, the idea of it is you shouldn't release anything I send to you that I don't want you to show to other people. That's the principle behind it. We agree on that, right? The principle behind it is if I show you something, if I send you something that I consider private, you should not be able to show other people it. And that's the principle why revenge porn in and of itself is wrong. Although the person willingly sent it to you, you cannot then show other people because they didn't give you the permission to show other people. Okay. And by the way, that did pass. So if you were thinking about getting involved in such reprehensible behavior, you would make a jail. You would go to jail and it would be good for you. But in such a case, here's my question. Do you think that it would be fair to include in this screenshots of private conversations? If I spoke to someone in confidence, I spoke a private matter to you. I told you, but my expectation was of privacy in this situation. And in the very same bill, they spoke about someone who has an expectation of privacy. And if my expectation when I speak to this person is of privacy, can they then screenshot that and throw it up in the girls group chat to make kicks on me and throw it up on a WhatsApp status to say, look at this fella, how he thirsty, or whatever they like to do with it? Could that now be done? Or shouldn't that also likewise be a criminal offense? Because you're sharing something private that the person shared with you that they expected to remain private.